Hi everyone, hope you all are doing great. Wishing you all a very happy new year. And today we are going to discuss about no fault liability. There are two types of no fault liability. Number one, strict liability. Number two, absolute liability. Let us discuss strict liability first with the help of a case law. Rylands versus Fletcher, 1861. Rylands and Fletcher were neighbors. The defendant, that is Fletcher, was an owner of a mill, and for the mill, energy was required. Therefore, he thought of constructing a reservoir by engineers who were independent contractors. While making the reservoir, they realized that there were mine shafts in the land, to which they neither covered nor they took ample care and constructed a reservoir on that. As a result, all the water from the reservoir flooded towards Rylands' land through the mine shafts, and due to which the plaintiff suffered heavy loss and sued the defendant. Issue: can Fletcher be liable to the fault made by independent contractors? The contention of the defendant was that it was the fault of those independent contractors. However, the judge, while delivering the judgment, said that the loss suffered by Rylands shall be compensated by Fletcher, and from here the concept of strict liability evolved. The rule of strict liability, or you could say the doctrine of strict liability, has three basic principles. 1. Dangerous thing. Thing which has been escaped must be dangerous in nature. Second, escape. Dangerous thing which is brought to the land for private purpose, and if it escapes to the area outside the control of the defendant. Examples: poisonous tree branches escaping from the compound of the defendant. Second, escape of dangerous animals, etc. Now coming to the third principle, that is non-natural use. However, it has few exceptions to the rule, such as number 1, if the thing escaped is not dangerous in nature. Second, if consent has been given by the affected person. Third, negligent plaintiff. Fourth, damage due to natural use of land. Fifth, act of God. Sixth, act of stranger. Seventh, statutory authority. If the government or the state makes any work as a result, there is some mishap, in that case, there is no one's liability. Now coming to absolute liability. The rule of strict liability, though, is strict in nature, however, it has some exceptions to it whereby the defendant could avoid his liability. He could avoid the liability. Whereas in case of absolute liability, which is evolved in M.C Mehta versus Union of India 1986, which leaves no defense to the defendant, making him absolutely liable. The principles of absolute liability are: number 1, that if an enterprise engaged in hazardous or dangerous industry which has the potential to threat the health and safety of the workers in the factory and in the neighborhood, owes an absolute duty towards the community to ensure that no harm is caused to anyone due to the dangerous activities which is undertaken in the factory. Second, the enterprise must follow all the safety standards while indulging in the hazardous activities. Third, if any harm is caused to the people working in the industry or in the neighborhood, the enterprise must be absolutely liable to compensate for such injury, and there shouldn't be any excuses even after reasonable care has been taken. It can be well understood with the help of this case law, that is MC Mehta versus Union of India, and this basically tells us how absolute liability evolved more than about the rule. More than the rule, it says how it has been evolved in India. That is this rule called absolute liability. In the year 1985, there was leakage of Oleum Gas from one of the units of Shriram Foods and Fertilizers Industries in Delhi, belonging to Delhi Cloth Mill Limited. In this leakage, an advocate from the Hazari Court died and several others were affected. A writ petition under Article 32 of the Constitution was filed on that regard. The Honorable Supreme Court held that old rule of strict liability was not binding and it could evolve a rule suitable to the socio-economic conditions of our country. The Chief Justice P.N. Bhagwati, while deciding the case, observed that the rule of strict liability was a 19th century law, when science and technology was not that advanced. Law has to evolve in order to meet the challenges of such new situations. So this was all about no fault liability. Thank you so much for watching. Please do not forget to like, share and subscribe to the channel. Bye bye.